Our last panel of the day is being moderated by Professor Lorraine Weinrib, who has a long history herself of working for the Attorney General for Ontario before coming as a constitutional faculty member here at U of T. And our last panel is government or attorneys general as interveners. And so I'll turn it over to Lorraine to introduce our panel members.
Thank you, Cheryl. I'm delighted that you're all here for this last panel. There has been some anticipation built up about the role of the various provincial attorneys general and, of course, the Attorney General of Canada, Department of Justice, in these cases. And the intervention applies to all of them, it's sometimes in ways that we're well aware of and sometimes in ways that are a little bit more hidden in the system. So I think that this panel will be one that will give you more insight into the larger system. I want to make a few remarks before I introduce the wonderful panel that we have assembled. The first is that this panel has observed many of the rules that have been adumbrated today for good interventions, that you have to have something to say that adds value, no repetition, and we have collaborated and we've strategized. So I hope that the panel will show that some of the skills of government intervention are in play here. I'd also like to stress the point that government lawyers who do interventions are some of the most frequent repeat players in the system. We've heard a little bit about that today, that people who are there in the provincial courts and especially in the Supreme Court of Canada frequently and who specialize in a particular area of law can develop an enormous rapport with the court and bring considerable expertise from various parts of the country and can also help the judges understand the ramifications of cases both in terms of rights and in terms of governmental power. And so, without further ado, I will introduce our particular repeat players. Michal Fairburn is counsel, Crown Law Office Criminal, Ministry of the Attorney General. She did her LLB here at the University of Toronto. She appears in all levels of court in criminal matters, and she's active in public education. Now, one of the things that she will provide us with is an insight to the intervention opportunities and the pluses and minuses of these interventions in the criminal context. Then Graeme Mitchell will speak. He's currently the director of the Constitutional Law Branch in Saskatchewan, and his law degree is from Osgoode Hall. And he has done 39 cases, constitutional cases, before the Supreme Court of Canada. So he is a repeat player par excellence. He has been there long enough to have gone through a number of cycles and to have done almost the full range of charter issues. And he will speak to not only the provincial aspect generally, but also being, in a sense, out of the center, if I can say that without offending anyone. His contribution will span both civil and criminal constitutional cases. And then we will finally invite Levine to speak. She's now the Executive Legal Officer, Office of the Chief Justice of the Ontario Superior Court of Justice. And so this is a second or third career for her, a graduate of McGill Law School. She was head of civil litigation in the Ontario Regional Office of the Department of Justice and then Deputy Regional Director. 30-year career at the Department of Justice, doing criminal, civil, administrative, and constitutional litigation at all levels, and also has been heavily involved, as are the other panelists, in continuing legal education. And so we'll start with Michal.
Thanks very much, Lorraine. And thank you for inviting me to speak at this wonderful conference this afternoon. I know that I understand, I wasn't here this morning, but earlier today you have had obviously a number of discussions about the role of the intervener and including the rules of the Supreme Court of Canada as it relates to interventions and so on. So what I think I'll focus on, as Lorraine has indicated, is the practical approach of a provincial attorney general in the context of criminal litigation in the Supreme Court of Canada, and specifically when it's determined that it would be appropriate to intervene, and how those decisions are made, what criteria are brought to bear, and ultimately how that crystallizes in an intervention that will be of hopefully some assistance to the court. There's really, in my mind, 4 critical rules for any intervener before the Supreme Court of Canada. The first is that they have to bring an objective perspective to bear. They're not there, obviously, in any sense to do anything other than advance a neutral position. They're not there to support a party per se, and that's sometimes hard for attorneys general because there is a certain perception out there that there's a gang approach when more than one attorney general is before the court, and so it's very important as an attorney general when determining whether to intervene to ensure that they're intervening with a certain sense of neutrality and bringing the objectivity to bear on the case that is required and really insisted upon quite appropriately by the court. The second rule is that the intervener is never to take a position on the facts of the case. And this is of critical importance, especially when it comes to the Attorney General, again, that they never come in and comment on the facts as it relates to criteria that the party Attorney General would have to necessarily have inextricably linked with their submissions. The intervener Attorney General is there only to assist on the law and the development of the law in the case. They are thirdly not there, and really no intervener should ever be there, to advance a new issue that isn't raised already in the court below. Even when an intervener sees a new issue, sometimes I confess I've even done this from time to time. I try to make it look like it's linked to an issue that's already before the court. You try to massage it into that issue that's live before the court or rises from the court below, but you really can't be there to raise a new issue that wasn't litigated below, because that's not fair to the parties before the court. And finally, and this is where I want to focus my chat now, you're there as an intervener, and it doesn't matter whether you're an attorney general or another intervener, you're there to bring a fresh perspective to bear on the issues that the court's going to be looking at. And historically, attorneys general have not been particularly good at doing that in criminal litigation. And that was recognized a few years ago, that in criminal, even in our discretionary, where we had to seek leave to intervene under Rules 56 and 57 and so on of the rules, the attorneys general will get in as an intervener and then often just do a Me Too approach. And that's not what the court's looking for. They're looking for a fresh perspective. What can you as an attorney general bring to bear on this case that the party attorney general isn't going to bring? And so, as a response to the perception that was conveyed by the court and conveyed kindly at times in a few cases and less kindly in others, where the attorneys general just seem to be piggybacking on one another, the heads of prosecution, which is a group within the country, so it's the head of prosecution of every province and territory and the now Public Prosecution Service, struck a committee called the Litigation Committee, which meets at the most every 2 months. Sometimes they meet more frequently. And there is, under this umbrella committee, a consistent approach to interventions then in the Supreme Court of Canada. And a number of things are looked at by this committee under the heads of prosecution. Before an attorney general, bearing in mind, of course, time constraints that may be operative, will seek even leave to appeal in the Supreme Court of Canada, they will often bring their case to the committee, determine whether it's an appropriate case to seek leave to appeal on, and then discussions will flow about, if it is an appropriate case, whether or not it would be of assistance to gain the input from other attorneys general in terms of intervention on the case. And there's discussions in that context and under that committee as it relates to what the various attorneys general can bring to the table. So I'll give you an example of this. It's a fairly recent example of how this kind of thing unfolds. The Patrick case, which you may be familiar with from last year, a decision of the Supreme Court of Canada. It's the garbage case, the garbage abandonment case, where the court ultimately ruled that a search warrant or prior judicial authorization is not required when seizing garbage from the curbside that's been left out for garbage pickup. So this is a PPSC case, a federal case. It arose in the context of a drug prosecution where the police had been gathering garbage bags outside Mr. Patrick's residence, which ended up being quite fruitful in terms of their contents and the trace drugs found in them and the various paraphernalia and so on. That case then, under this protocol that's been set up under the heads of prosecution, because it was an appeal as of right to the Supreme Court of Canada on a dissent from the Alberta Court of Appeal, came to the committee, and the federal government sought the assistance of certain provincial attorneys general on the case, because the concern was that the Supreme Court of Canada was going to decide this case simply on the basis of sort of a drug backdrop. And was it appropriate for the court to only have that kind of perspective brought to bear in a case of such important constitutional interests at play, but also investigative interests at play? As you, I'm sure, are aware, abandoned garbage, and I can now call it abandoned garbage because that's what the Supreme Court of Canada unanimously called it, is quite helpful in the context of criminal investigations, murder investigations, sexual assault investigations, and so on. And so the question was, could a provincial attorney general bring that factual backdrop and their unique experience in prosecutions to bear in the Supreme Court of Canada on that type of constitutional question? Now, of course, the flip side is that the provincial attorneys general, when they're dealing with garbage, here I'm talking, of course, about abandoned garbage again, not a garbage case in the broader sense, they, you're going to bring a certain constitutional flavor that might not be of assistance to the Supreme Court of Canada, because we're talking about DNA seizures. We're talking about things that are going to engage a far more serious privacy interest than drugs coming out of garbage bags. And so this heads of prosecution committee allows the attorneys general ahead of time to discuss these issues, to work them out, to determine whether it would be in the best interests of the case and the position of the party attorney general for others to come in, what the upsides are of it, what the downsides are of it, and so on. So there's quite a structured approach that's brought to bear in that context. The committee also identifies very early on whether there are interveners outside of attorneys general whose assistance may be appropriately solicited by the party attorney general. So in some cases, the Canadian Association of the Chiefs of Police will be alerted by the attorneys general that there may be an issue they're interested in intervening on. It may be in some cases other public interest groups will be approached. Public interest groups who have had tremendous and successful impact, and this is coming back to a question I heard asked of the previous panel in terms of, well, are you doing this for any good reason? Is there actually an impact? And I can tell you, having litigated in many of these cases over the years, that there is no question that those interveners have an absolutely critical impact in the context of the development of constitutional issues in the Supreme Court of Canada. We can't do without them from the public perspective, and they are responsible largely for things like, and I thought our colleague who spoke to the Gladue courts made an excellent suggestion, but quite frankly undersold it, because in Toronto we've got Gladue courts, and they're responsible for that, but they're also responsible for the Gladue application for every single First Nations person who comes before a court in the country, with or without a Gladue court. And that's critical. And the attorneys general will be looking for public interest groups often to intervene to advance those positions. And one needs to look no further than cases like Mills and O'Connor and so on to see the critical importance of those groups. So those are the kinds of things that this Heads of Prosecution Committee talks about. And how it is determined most often that leave to intervene will be sought in the Supreme Court of Canada, and how it can be, how a fresh perspective can be brought to bear and advanced outside of the actual party's position. Now, I thought I would also just spend a few moments contrasting that with the actual right to intervene by an Attorney General in the Supreme Court of Canada, because it's fundamentally different. Under Rule 60, of course, of the rules, if there is a constitutional question stated in a case, then the Attorneys General actually come in as of right, and they don't come in under the 10-page rule, they come in under the 40-page rule. And they don't have to be asking to come in. And I often wonder times why it is that some parties who are not an Attorney General seek to have a constitutional question stated under Rule 60, because of course you can have a constitutional issue stated quite properly in the context of when you're challenging a piece of legislation, but you can also have it stated at your discretion. Sometimes the court will impose it of their own motion. But you can ask to have one stated in the context of a case where you're challenging a common law rule or the applicability of a common law rule. And sometimes parties do that. There's a very recent example of it in a case called National Post that was argued in May of this year, where the application of the common law rule as it relates to press informant privilege, the party, National Post, asked for a constitutional question to be stated there in its intersection with Section 2B of the Charter. Now, what's interesting is the Chief Justice stated the constitutional question. And I wonder sometimes, from a party's perspective, when they're not an Attorney General, why they necessarily want to do that. All the same constitutional issues can be before the court without the constitutional question having been stated. All you're doing as a party, when you have it stated, is you're sending out a direct invitation to every Attorney General in the country to come in with 40 pages to meet your argument. And they don't have to bring a fresh perspective. They don't have to ask to come in. They're there as of right. And so I sometimes wonder about that. So in National Post, immediately upon the constitutional questions being stated, the AGs just started filing. They were all coming in. Now, as it ended up at the end of the day, resources being what they are these days, a lot of the Attorneys General didn't end up crystallizing their interventions, but still the National Post was met with about 120 pages of AG's factas at the end of the day. And I'm not sure that that's of the most assistance to the party. But that's the distinction between a non-constitutional question case and a constitutional question case. 2 seconds on oral argument, and then I'm going to hand it over to Graeme. It's really important when there's a number of attorneys general in the Supreme Court of Canada that we provide assistance to the court. And so that doesn't mean repeating of submissions. It doesn't mean taking an overly structured approach. It means getting together ahead of time. There's actually a protocol in place on this, again under the Heads of Prosecution Committee, where the AGs are instructed to get ahead of the game 1 to 2 weeks in advance. They're to have a conference call to make sure as their submissions or oral submissions are developing that they're not going to be overlapping one another, that everybody's going to be standing up and saying something different. And then 1 to 2 days in advance, the protocol says the AGs have to actually sit down in Ottawa and make sure they've got their acts together on this front. It doesn't always happen so well, but that's the idea under the protocol, and it's certainly the expectation of the court. But with that said, it's anybody's guess what's actually going to happen when you're there and arguing these cases. In my experience in the last few years, because the court seems to be moving toward this 10-minute rule, and I mean, really, what can you say in 10 minutes? I've probably already blabbed for about 14 or 15, so I'm about to close it down, but my red light would have gone on a long time ago, there's no doubt about it. And the Chief Justice would be telling me to sit down and shut up. But the thing is, I think as an Attorney General intervener, and frankly as any intervener with these tight timelines now, the best thing you can do is listen to the parties who have gone before you. As Ontario, we're up after the party. If we're not the party, and the AG Canada is the party, we're up right after AG Canada if they're the party. If AG Canada isn't the party, AG Canada after the party, and then Ontario will go. And I think Graeme's going to get into the actual rule on that, so I'll leave it with him to explain better. But the best thing to do is listen to the court. What's the court asking? What's the court troubled with? Who's saying things where you're thinking, oh my. If that's the way the justices are expressing themselves now, this is going to be a real problem in terms of the judgment. And just to stand up and say, Justice Fish, you asked this question of my colleague X, I'd like to answer that question now. You asked this question of so-and-so, and I think that's probably the best role of an intervener, to do sort of the cleanup work. So I think with that said, Graeme, I'll turn it over to you.
Thank you, Mikkel. Like Mikkel, I too would like to extend my appreciation to Cheryl Milne and the Asper Center for Constitutional Studies for inviting me to participate in this seminar. I think it's a very important issue, the whole role of interveners in public litigation. And I should state that the views that I'm going to express to you and the positions I'm going to advance do not represent the position of the Saskatchewan Attorney General or his ministry. I've been asked to bring the perspective of a smaller jurisdiction to the whole question of interventions. I come from a ministry where we have a branch of 8 lawyers, but only approximately 3, maybe 4 of us deal with constitutional and charter issues on a regular basis. So we lack the richness of the resources that would be available to the Attorney General of Ontario or the Attorney General of Quebec and even the Attorney General of British Columbia. So we have to be fairly lean and efficient in how we do our interventions. So in the time that I've got allotted to me, I was going to use a line that I had 15 minutes, which was 5 more than they allow me in the Supreme Court of Canada, but Lorraine told me I only have 12. So I will, I want to cover 2 general areas. I want to give you a flavor of what we do in the province of Saskatchewan, so you get a sense of interventions in a smaller jurisdiction. And then I want to talk about the role of provincial attorneys general as an intervener before the Supreme Court, and particularly the kinds of things I think about when I bring an intervention and when I participate in the intervention. I want to preface this, however, with sort of stating my philosophy about interveners, and I'm very supportive of interveners. I think they are very critical. Like Mikkel, I think they bring a great richness to the discourse. Even the ones that disagree with the positions I'm advancing, I think it's very important that those voices be heard. And I, too, have great admiration for the individuals, such as the panel before us, and even defense counsel, who are very much who very much bring different perspectives, but very important perspectives to the dialogue. That said, in Saskatchewan, the courts in our jurisdiction are, I think, to put it charitably, skeptical of interveners. Interveners are very rare in our courts. In fact, the leading case on the intervention in our Court of Appeal is a case that took place in the first Latimer appeal, a matter of Robert Latimer, and there was the initial appeal. There was a couple, 2 intervener groups that wanted to see seek intervener status at the appeal hearing. And the court, and I would say with some reluctance, allowed those two interveners in. The reluctance has softened somewhat. We've had more examples where interveners have been permitted to participate, but it still is not a common phenomenon in our jurisdiction. Now, I want to distinguish interveners in regular appeals from references. References, of course, under our Constitutional Questions Act, there is scope for a great number of parties to participate in references, and it's clearly there at the discretion of the court. To my knowledge, they do not apply the criteria, the rather strict criteria that the court set out in the Latimer case. My experience as an intervener as a counsel for the Provincial Attorney General in our provincial courts, both Court of Appeal, Queen's Bench, and the Provincial Court of Saskatchewan, I do it perhaps in two general areas. Firstly, in the criminal area, where a law, and typically a federal law, a law under the Criminal Code or the Controlled Drug and Substances Act or something like that, is challenged. Or we may be called upon to defend a provincial law in litigation where the government is not a party. If there are either private parties involved in a law, constitutionality of a law is implicated, or in a circumstance where there's a public agency involved, but the Attorney General himself is not a party to the litigation. And those are the two, by and large, the two general category of cases in which we participate. Whenever a law is challenged, particularly a provision of the Criminal Code in a Saskatchewan court, it falls to the Attorney General of Saskatchewan to mount a defense. In all the years I've been doing this, and there are those that probably would say that I've been doing this far too long, that I have never had the participation of the Attorney General of Canada in our provincial court system, in the courts of Saskatchewan. And despite the fact that this is the practice, it has really worked well. But on occasion, it would be nice to have the active support of the Attorney General of Canada. I don't wish to suggest this as criticism. I'm just saying that this is the practice that's or the experience that we have in Saskatchewan, and I suspect we're not alone. In fact, I know we're not alone. That the practice in many of the jurisdictions is that it falls to the provincial attorney general to defend a federal criminal law in the courts of that province, and then the Attorney General of Canada will participate should it go higher to the Supreme Court. And I just wanted to highlight an example of a case. Some of you may remember the case of the Queen and Lucas, which was a challenge to the criminal defamation provision, section 300 of our criminal code. And we had a challenge, and we also had there was a challenge that had proceeded earlier in Manitoba. And in that case, I made some contact with the counsel for the AG of Canada and told them the situation. And the counsel said to me, "Oh, don't waste your time. It's clearly unconstitutional." And I said, "Well, I understand there's a case going on in Manitoba." She said, "Well, yes, but it's really it's just a waste of time. You're going to lose this case." So I contacted my good friend Sean Greenberg, who was then counsel with the AG of Manitoba. She's now Madam Justice Greenberg of the Manitoba Queen's Bench. And Sean and her colleague had done an absolutely spectacular job of researching this issue. And to the extent that the Manitoba Court of Appeal adopted essentially the research that the AG of Manitoba had presented in a decision called Stevens, which made my job in Lucas extremely much easier, because I was able to build on the record and build on the judgment that had been done in Manitoba. And then we all went to the Supreme Court and were joined by counsel for the AG of Canada, and lo and behold, we were able to sustain the constitutionality of that particular provision. So the moral of the story is it's not always a good thing to listen to the advice of the counsel for the Attorney General of Canada. In respect of the non-criminal matters, and we intervene, as I said, when it's either a private party litigation or there's another public agency. And one wouldn't think that happens all that often, but in fact it does more often than not. In fact, right now, I'm involved in a number of challenges to some recent labor laws that have been enacted in our jurisdiction. Those of you that follow politics will have known that in November of 2007, the previous New Democratic government was defeated, New Democratic Party government was defeated by a young party called the Saskatchewan Party, which was an amalgam of the old Progressive Conservative Party, some disaffected Liberals and reformers. And they are now the government. And one of their first items of business was to amend some of the provisions of our labor relations legislation. And in particular, they created and enacted a Public Services, Essential Services Act, and they did some amendments to the construction industry labor relations regime that had been in place in Saskatchewan for a number of years. Decades, actually. And now we're facing a number of challenges of those particular provisions as part of certification applications and challenges to the designation of services as essential in the Saskatchewan Labor Relations Board. In fact, there are 4 of them that I'm currently dealing, as well with a couple of lawsuits to the litigation, but in which we are named as a party. But before the Labor Relations Board, we are interveners, but both the parties on both sides, plus the board, is looking to the AG to present the constitutional issue, and we are effectively responsible for that, and we are viewed as almost a full party in that litigation. So those are the 2 situations that, in my experience, we participate as interveners in the courts of our province. Now, turning to the role of a provincial AG before the Supreme Court, I want to say that it is a very unique role for counsel to be an intervener counsel, regardless of who you represent in the Supreme Court, and it's a very specialized one, as we've already spoken of the fact that you have only 10 minutes to make a presentation. And I've always thought of an intervention really as a surgical strike. You have maybe 2 issues that you can go in on, 3 if you're lucky, and you have to be really strategic as to the issues that you wish to focus on. And these are typically issues that, at least when I do an intervention, I think are the issues that are important to your jurisdiction and issues that you think will be of value to the court. And you really can't go into great detail on them, and you have to flesh those out in your factum. But those are the those are the kind of issues that I want to bring to the court's attention in my oral argument. I want to put forward a proposition that may be rather controversial, but in my view today, I don't think it's a controversial proposition, but I may be controversial today. And I think an AG is not a regular or just another intervener. He or she carries a statutory and constitutional obligation as chief law officer of the Crown, of the province or of Canada. And the Supreme Court of Canada reminded us, if not themselves, in the recent decision of Krieger and the Law Society of Alberta, of these particular and unique responsibilities of an AG. And I think it's my respectful submission that the court needs to be respectful and sensitive to the significant public and constitutional role that AGs bring to the table and bring to the intervention and the case, and that we shouldn't be thrown into the hopper with the rest of the interveners. Speaking from personal experience, we weigh very heavily when to intervene. In smaller jurisdictions, we don't have the luxury of going into every case which is of important interest or is of interest to us. So it's a very careful decision whether or not we will intervene. And I think what the primary focus, of course, of that is that we would, if we can bring a perspective or a position that we believe is valuable for the court to hear. We only intervene in cases in which a notice of constitutional question has been stated. We've only, to my recollection, intervened in what I think are called Rule 18 applications, where you have to seek leave to participate. The first one that I can think of was in a case a number of years ago called the Queen and Stillman, where we were allowed to file factum and give an oral submissions. And then we did it most recently in a case called Miasgan-Cavallo, which I was delighted to learn today. The appeal from the Saskatchewan Court of Appeal was overturned, where we were given right to file a factum, but were not given oral submissions. So those are the only times that we've done that. But so we focus partly because of resources and partly because of what we can bring to the table on notices of constitutional question. And in that, in my role, I try to bring the perspective of the chief law officer of the Crown for Saskatchewan to the particular issues of the court. And then I like to bring to the attention of the court issues, local experience, with the issues that are before the court, and maybe jurisprudence, case law that is local, that may be of interest to the court as they deliberate on the appeal. And I describe this as bringing a regional flavor to the issues before the court. Now, what do I do at a hearing? Well, I arrive at the hearing usually with some kind of written presentation. When I first started doing this, I literally wrote my presentation out verbatim, but over the years I've gotten away from that because the presentation I ultimately deliver orally may be very different or may differ in great respects from what I had brought with me written. Cal has referred to the order. The order in the court is you speak in accordance with your admission to Confederation. And so, except for those cases in which Newfoundland and Labrador participates, Saskatchewan comes at the very end of the AGQ. We, as you all know, went into Confederation at the same time as Alberta, but sadly, A trumps S in the alphabet, so we come at the end of the line. So at that time, I'll have heard the questioning, I'll get a sense of where the court is going, some of the issues that are troubling the court, and in the course of the presentation, I will try and revise and reorganize my presentation. And I'll try and tailor it to the issues that the court is concerned about, but also trying to be mindful of trying to bring a regional perspective. We've talked about, there's been talk about repetition. We meet, certainly we meet the day before, try and divvy up arguments. If a number of people are dealing with the same argument, we'll try and make sure that there's the least amount of repetition. We may have discussions in the factum development stage to avoid repetition, or maybe somebody may want to emphasize an issue more than because it's an issue in their jurisdiction as opposed to our jurisdiction, and there's more law and more information that they can bring forward in their factum. So we do have informal consultations throughout the factum writing and prior to the hearing. And we do our best to try and avoid repetition, but I do want to emphasize that repetition is not necessarily a bad thing, particularly when you are bringing a regional perspective to the court, that it's maybe useful for the court to hear the same concerns or some of the same views, but from a different perspective and how it's playing out in the ground. So that's sort of how I try and package an intervention. I just want to conclude with two very quick observations about the current, what I perceive is the current climate for interveners in, particularly attorneys general in the court. First, I'm generally troubled by a court that I think is less tolerant of interveners than they used to be. I haven't done the statistical research, but anecdotally, the number of cases that have interveners are not that many. And the ones that do have them, they raise important public issues. And it's useful to get as many perspectives before the court as possible. So I worry about our public discourse being a little less rich if there is either people are being excluded, or if they're not, if oral argument is not being advanced as much as it, in my view, it should be. And again, I've touched on this, but I'm also troubled by a court in which AGs are sort of thrown into the hopper and treated as a regular intervener. I think that does not respect the unique role of the AG and the care with which counsel for the Attorney General brings the perspective of the particular AG and the province which we represent. Thank you.
Thanks very much, Graeme. And now we'll move over to AG Canada with the interesting perspective that Roz brings, because she doesn't actually work for AG Canada.
That's right. So that's my first disclaimer. Everybody else has disclaimed any opinion on behalf of their employer, and I'm now going to disclaim the same thing, except that the presentation I have today is not really related to my current employer. So this clearly does not reflect the views of the Superior Court of Justice, where I now work. And but on the other hand, I always say, when I'm referring to the Department of Justice, having spent over 30 years there, I always say we and our, because old habits die hard. So when I do say we and our opinions and our policies, please take that as a reflection of the Department of Justice's policies when I was with them. And I have updated, and I've spoken to a number of my colleagues in preparation for this presentation to make sure that I was up to date. So first of all, the federal perspective, I think is somewhat unique from the provincial perspective as in choosing to be an intervener in a case. But I just want to talk first about some of the policies and practices and internal process, which do remain the same to this day. At the federal level, first of all, now in criminal matters, there is the Public Prosecution Service of Canada, as distinct from the Attorney General of Canada, that weighs in criminal matters. But in both of those bodies, and both of them are really branches of the Attorney General, in both of those bodies there are very formal processes that go up through litigation committees where counsel who think that there is a case to intervene has to present those arguments very cogently, has to meet the tests, and it will go to the deputy minister on behalf of the minister to actually determine that an intervention in any case, whether it's as of right or not, whether that case is going to go forward as an intervention. And in trying to make that case, clearly the department has to ensure that it meets the tests. I mean, that would be a basic requirement. Can we bring do we have a direct interest? Can we bring a unique perspective? And so that would be the very basis of it. But clearly, the government can't go in every case, and I'll address that a little later in response to Graeme's comments about how no one ever showed up in his cases. But that's actually a good thing, so I'll leave you hanging, Graeme. So once the test for intervention is met, then the question is there a policy point that needs to be made? Is there a similar statute if we're going to intervene in a provincial case of statutory interpretation? Very often there are overlapping statutes, labor laws, for instance, in which there will be similar provisions in both provincial and federal statutes, and therefore we want to protect the interpretation that the federal government may have in respect of a similar section. And then often there are just large social policy issues, such as universal public health care. And so the federal government, although it's not its area of jurisdiction, may clearly want to be an intervener because it is a large social policy case. one of the aspects that I also want to bring to this little presentation is that the federal government, like provincial governments, are very often on the receiving end, because we're parties in all constitutional litigation. We are on the receiving end of interveners, and we have to deal with the fact that there are so many interveners who want to come into our cases when we are parties, and that presents some challenges as well. Clearly, getting into court, we have a great advantage, like the provincial attorneys general, because there is, as of right, the right to come in as an intervener in any constitutional case. But there's also an advantage, and I've used it in some occasions, where there was a constitutional question stated, and that might have been a lesser interest to the Attorney General, but there was another issue that may not have been a constitutional issue, and it's certainly easier to get in on a case like that rather than going in as an ordinary intervener and having to meet the tests. If you're already in as a constitutional intervener, I think the court is more likely to allow you to speak on the non-constitutional issue when you're already in on the constitutional issue. And that was, I think, the case in BR, which was a freedom of expression case relating to Jehovah's Witnesses, and freedom of religion, and it was a blood transfusion case, and I went there on behalf of the Attorney General as intervener, not just in the constitutional aspect, and in fact we made very few submissions because there were others that could make the submissions. In fact, the province could make those submissions, but we were very interested in the issue of costs, because in that case the court had ordered the intervening Attorney General to pay all the costs of the entire litigation. So clearly that was a huge policy principle, non-constitutional, that interested the federal Attorney General. Since we do intervene in so many cases, did we want to end up being the bearer of the costs of the entire litigation from 3 levels? And so we asked the court to opine on that. So there are some hybrid cases. And then, of course, there are the decisions to intervene in non-constitutional cases. And we think that often there is a perspective that the Attorney General can bring, and the Federal Attorney General can bring. And I think that relates to the national identity of the Federal Attorney General, trying to bring a perspective that is a national perspective, that is a consensus of a central opinion that takes into account all the areas and all the regions of the country that do have their own particular character and their own particular opinions. And I think that really is the benefit of both having provincial attorney generals and federal attorney generals as interveners, because there are unique perspectives of various regions of the country, and the court benefits by having those perspectives. The usefulness, I think, also of having provincial interveners in many of the cases of federal issues is that it is useful and strategic, as many other non-attorney general interveners have found, to divide common issues of public interest, and we often use that strategy and often work hard to divide out the argument, both written and oral, to ensure that we're not duplicating, but that all the issues can be addressed. And clearly we have some advantage there, but so do interveners in large social policy cases. And because I have 2 minutes, I think I'm going to move right to that. And that's my perspective over the years of litigating in large social policy cases, same-sex marriage, what I call the spanking case that Cheryl calls the Section 43 case. And that is the political nature of interventions. And here I'm going to talk mostly about the non-attorney general interveners, just interveners in general. In large public interest litigation, it's very clear that interventions have become extremely political. Each of the parties in those, or each of the interveners in those cases, have a particular political agenda. They make no bones about it. This is not a revelation. Everybody knows that these are highly politically charged issues. But what I sense is that there's some thought that many organizations whose positions overlap feel the real need to be there because, in a sense, everybody wants to be at the party. And that certainly was the sense, then I see Doug nodding, that certainly was the sense in some of the same-sex marriage litigation. And especially because it looked optimistic and it looked like everything was moving towards a successful conclusion. And so if you had worked hard for the many years on these pieces of litigation, you wanted to be at the party. And I think, though, there's also, and maybe this sounds a bit cynical, but I think it's probably totally legitimate for these groups to want to be there because they want to be visible to bolster their justification for existence. And also they need to be visible for their supporters because it's a matter of fundraising for them. And so this is a way to highlight that visibility, to bolster that visibility, and to say why you count. So sometimes for the attorneys general in these cases, it becomes very hard to manage that kind of issue and try to set out where you should be neutral, whose interventions you should agree with, whose interventions you should oppose. In all of the cases that I had, we tried to really achieve a balance. There sometimes was a sense of piling on, and I think that was part of our own role as attorneys general to try to ensure for the court that they did have a balance by exercising our discretion to say we either agreed or we were neutral or we disagreed with any interventions. We usually started from a position of neutrality if these organizations were experienced, long-standing, and had, as Justice Iacobucci, or as Mr. Iacobucci said, had special expertise and knowledge to bring. And clearly the court, I mean, you heard it here today, but and also the empirical evidence is that interveners are very important for the court. In my view, from the Attorney General's perspective, when the Attorney General is a party, is to have a balance and not to allow piling on one side or the other. And Justice Major at one point, I think in the early 90s, tried to put a signal out that maybe the court should be more vigilant because he sensed there was this piling on to try to influence one side or the other in social policy cases especially, and he thought that the court should rein back interveners, and clearly that didn't have any traction because, as we saw from the chart, interveners have continued to increase in these kinds of cases. I'm just going to move right to the end to the time limits for interveners. Now, strangely, I think that interveners often have an advantage. Having been an Attorney General party in cases, and I think both of my colleagues here would probably agree, you get about 3 minutes to introduce your argument before you get a barrage of questions for the entire hour. You never get to cogently, articulately take your argument through from beginning to end, and often it's very scattered, and you're answering a question on a topic you wanted to address at the end, at the beginning, and it really doesn't come out in that in the style that the true advocate would want. And so the interveners, I've noticed, however, often have 10 minutes of uninterrupted advocacy where they can build within that 10 minutes, and that's the true skill, an argument from beginning to end on the points that they want, and the court will not interrupt them. And I saw that in Hislop, Doug, when I remember Dan Gutman for the province of Ontario seemed to make one of the best, most cogent, most articulate arguments, and I was so glad that they were there as an intervener, because if they had been a party, they would have had the same barrage of questions that we have. There really is at this point no 10-minute rule. It's a practice, and of course the court has started to exercise its discretion not to allow some interveners to even have any oral argument at all. I'm not that troubled by that, because I think when all is said and done, at the end of the day, you remember that your factum is what goes to their chambers with them. Decisions, especially in the Supreme Court, but in almost all these cases, because they're of some import, judgment is not delivered from the bench. So they're taking your argument, your written argument, back with them, and that's what I want them to have. And I think that the importance of of factums has increased, probably tenfold. And a really, really well-written factum, I think, can stand you in much better stead as an intervener than your 10 minutes in the limelight, especially when you're there serially with 10 or 12 or, as in the same-sex marriage reference, 27 other interveners. So that doesn't trouble me very much, and I think that that's where the emphasis should be when interveners do intervene in the court. And on that, I will end because I think my time is up.
That's fine. That's wonderful. Okay, well, I know it's the end of the day and we're moving towards wine and cheese, but we have a few minutes for questions, and I would very much like to receive questions for the panelists. Doug Elliott.
As I was sitting there, I was recalling that in the Levine case, the Attorney General of Canada intervened against the interests of the Attorney General of Alberta, which, in my experience doing gay rights litigation, was a refreshing change. But I just wondered, was that an unusual thing? Does the Attorney General intervene against the interests of another government in charter cases very often? Or on the flip side, do the provincial attorneys general intervene against the interests of a government in a charter? And I'm thinking particularly of charter cases. And if so, if that wasn't a one-off, what are the special considerations that apply, considering that normally you're working in cooperation?
Well, it's not a once-off. It certainly happens in criminal. We don't like to conceptualize it, though, as intervening against another attorney general. We just like to talk about the fresh perspective or the ultra-fresh perspective in those cases. It's a sensitive thing. Quite clearly, we make sure that we have discussions ahead of time so it doesn't come as a big shock to the other Attorney General when we do it. And we like to, when we're contemplating doing it, have these discussions ahead of the Attorney General actually formalizing their submissions. So we try to get their submissions from the Court of Appeal quickly and have those discussions ahead of time, because sometimes the other AG will actually potentially change their position based on how fruitful these discussions are. But if they don't, I've been involved in those cases. They're uncomfortable, but they do happen.
In my experience, any time it's Attorney General versus Attorney General, whether as intervener or as parties in cases, that is, as Mikhail says, a very sensitive issue. That's not to say that we don't do it, as you know, and that's where the idea that there are regional perspectives, and we have to respect those regional perspectives. But when I think it comes to the very core of a federal policy, then that will be when the decision will be made, which is not the answer, and I didn't answer, Graeme, that's not the answer to why we don't intervene in criminal cases. In those cases, in many cases where the provincial AG is there, we don't come in simply because we don't have the resources to do that across the country. And if we have confidence in the council at the province who is handling the case, then we will rely on that. And so, Graeme, you should take that as a sign that we had the utmost of respect for you and knew that the cases were well in hand, and not as a slight at all.
No, I didn't. If I could expand the question just a tad, because this is a really important, this has become an issue in federalism cases particularly. There's been statements in jurisprudence, say, in the last 10, 15 years, where the court has commented on the fact that the AG of Canada and the provinces are coming in and advancing a similar position about the constitutionally in a division of powers sense of a law. I think we saw it, and there's two examples which are very recent. Chatterjee and the Ontario Attorney General, which was the challenge to the Civil Remedies Act. The court was very open about the fact that they were moved by the fact that the AG of Canada and any number of attorneys general were on the same side. And I think actually, while I think they came to the ultimately the right conclusion, I think as a consequence, some of the arguments on the other side that were good kind of got short shrift because they had a lot of AGs there. The other case, I was talking about this at a meeting earlier today. There was a case which actually probably got very little radar in English Canada. It was the reference on Assisted Human Reproduction Act reference, which was a case out of Quebec, very important criminal law power case. And there was only 3 attorneys general that intervened on behalf of the AG of Canada. The AG of Quebec in that case. And the AG of Canada, no disrespect, Rosyln, but the council started off by saying, who is not here today? The jurisdictions that have the most examples of assisted human reproduction in the country are not here. And the unspoken word was, and we've got these pygmies of confederation here that are arguing against, so it's becoming an issue, certainly in federalism cases, that it's important that there be a united front on behalf of the AGs.
Thank you. Hassan Mirza, I'm a student at Osgoode Hall. My question was related, in the earlier panels we heard a lot about financial resources and human resources as being an important criteria in deciding to intervene, in contrast to the current panel where that didn't seem to come up very much. So a layperson may conclude from that, like myself, that when a government thinks it's important to intervene, financial questions are sort of not front of mind, the same as private or non-profit. Would you agree? And if you disagree, would you give an example of a situation where intervention was important but the government didn't intervene because of financial situations?
Well, resources issues is always front of mind for us as a jurisdiction. I think it's probably fair to say that the resource, if we want to go, if it's an important enough case that we feel we should intervene, there is the resources there. We are salaried lawyers. So the fact is, it's not going to cost the government as much to send us as it might be for a private party to send a private bar lawyer to intervene on behalf of a particular party unless they're prepared to do it pro bono. So to that extent, you're right. There is not the financial constraints as much. But don't be fooled to think that AGs have bottomless pockets, and we can send out a team of lawyers to deal with a case, because that is just not my experience at all.
I would just simply add to that, and I agree with everything Graeme said, but working in criminal, and I should say, lest I be, Dalton McGuinty hear this down, just slightly down the way here, that the, Ontario government, we've got a resource issue and all that, but working in criminal, we don't tend to feel that quite as much, because the reality is public safety is often the issues we're going to the Supreme Court of Canada on. They're weighty issues. They're ones that the public typically are quite behind in terms of public expenditure. So I'm in the somewhat luxurious position, which I never fail to appreciate at all, that the money tends to be behind the criminal law division, rightly or wrongly. It's there. And sometimes for these other interveners or would-be interveners or parties, we will actually, if we're coming in Ontario as an intervention and we think that others who are less resourced might suffer financially, we will actually offer, as part of our request for intervention status, to pick up the bill of those who might suffer. The party, for instance, we're not going to pick up AG Canada's bill, that what they're going to suffer as a result of our intervention, or, sorry, Graeme, even, Saskatchewan's, but others, we certainly would do that in reasonable circumstances in order to make our presentation, but ensure that it doesn't have that kind of impact.
No, might as well just let Mary ask. I think that those are well answered, so I don't have anything to add at this point.
Okay, so we'll have one last question from Mary Everts.
Thank you. Mary Everts, and my question invites you to grasp the political nettle. I've heard on this panel and on some others today about how political some of the interveners from civil society seem to judges or to attorneys general. There's a bit of a disconnect here, because I think you guys as members of the public service actually work for elected governments, and the last time I checked, the election of governments was done through politics. And so how come, those of us who are often representing the disenfranchised and the disadvantaged are seen as political, whereas attorneys general wrap themselves in the mantle of the public interest? And how can that happen in a system where the Attorney General, while a chief law officer of the Crown, is also a member of the Cabinet and bound by Cabinet solidarity? I mean, do we not have a bit of a disconnect here?
I would be happy to start the response. And clearly you're absolutely right that there's no question that the positions of the attorneys general are determined by the policies and therefore the politics of the day. I think there is a distinction in being the voice of an elected government and the policies of an elected government. And I also think that most of the council who represent the attorneys general as interveners try extremely hard to present a neutral perspective. Now that doesn't mean that that can always be the case, and I guess my concern is not so much that the interveners are political. I mean, that's the reality. I guess it's a question of balance. Once again, that are you going to have a huge political position on one side of a case that isn't balanced off by the opposing political position on another side of the case, because each of the parties that comes is an advocate. And I think, or the non-governmental parties are advocates, and I think they make no bones about that. We try our very hardest not to be advocates in the sense of being wedded to a particular position. We try very hard, I think, to bring the evidence in a neutral way to the court. And whether we succeed or not, maybe we don't in some cases, but I would then say that it's the fact that we represent an elected voice as opposed to those who simply want to come at will to the court and provide their political advocacy.
I'm not troubled by the political nature of interveners. In fact, I think that's what interveners, particularly non-governmental interveners, do. I mean, and some do it better than others, and some do it extremely well. What I liked about the question, and I wanted to comment on, you're right. There is a kind of oddness to the AG in our system as opposed to the Attorney General in England, who is outside Cabinet. I referred in my remarks to the case of Krieger and the Law Society of Alberta, where the court acknowledged that there was a political aspect. I want to touch on an aspect, something that I lament, and that's the lack of the independence of the AG. I've been troubled over the years that I've been counsel that we are losing, and that the independence of the Attorney General often turns on the particular person holding the office. And that's a trend, and all I'll say is I'm grappling with it right now at home. I think it's I really do lament the fact that we are losing the very strong independence of the AG. And if, this may sound like a cri de coeur, but I wish there was a rejuvenation of the strong, because he has all the attributes. You say we clothe ourselves in the public interest. That's because that's what the AG represents. And I wish there was a little bit more of that.
And the only thing I'd add is, again, I wake up in the morning and I go to bed at night grateful that I work in the criminal law division in Ontario, because we are, and I appreciate there's an inextricable link and there's an uncomfortable marriage with not this specific Attorney General, but any Attorney General at the provincial level. But we're an independent prosecution service. The Attorney General has absolutely no control over our decision-making power as an independent prosecution service, of which we're very proud. And in fact, so much, the Attorney General has no input one way or the other on the criminal prosecution service's decisions to bring applications to intervene in the Supreme Court of Canada or anywhere, unlike other members within the other council within the ministry, where the Attorney General does have the ability to have some input on those cases. So we live in a more unique and independent world that I'm happy about in criminal, because I can actually write FACTA and file them, finish writing them the same day they're filed in the court without having to ship them upstairs like my poor colleagues in other divisions within the Attorney General's office. Yeah.
Thanks very much.
Thanks. Just as a footnote, I don't have to vet my cases.
Thank your patience for staying a little over time to allow this panel to finish and answer your questions. And I want to thank the panel again for, really, it's been a really rich day. I've enjoyed it. I hope you have as well. And the reward at the end is a drink upstairs. And the reception is in the faculty lounge. So if you go past where the reception desk was when you came in, and turn left through the doors, and you can find the lounge through there. So please join me in thanking the panel, and thank you.